Litigation Committee of the section of Nigerian Bar Association section on legal practice, titled the Tax Appeal Tribunal's Expanded Jurisdiction, Resolving Conflicts Between the TAT and State High Courts. And right about now, it's my honor to ask and welcome the chair of the MBA section on legal practice, Mrs. Falashade Ali, SAN, to deliver our welcome remarks. Thank you very much, ma'am.
Thank you, Mr. Ajala, and good afternoon, everyone. Thank you for joining today's webinar. It's an honor to welcome everyone, both the participants and our speakers who have taken time out of their busy schedule to be here this afternoon. On behalf of the Litigation Committee of the MBA Section on Legal Practice, I welcome you to today's session. The session is dealing with a topic that, for me, has become very, very important in Nigeria. When I saw the topic, the Tax Appeal Tribunal's expanded jurisdiction, resolving conflicts between the Tax Appeal Tribunal and State High Courts, I thought, well, it's high time that we really discuss, the frontiers and what is going on. So thank you, Mr. Musa Atta and your team again for curating such a topic that deals directly with the challenges some of our members are facing in courts and tribunals across the country. This just shows that we at Section on Legal Practice commitment to excellence in legal practice, and we continue to hope that we'll be able to assist our members to deal with and to know their rights and how exactly they can deal with such problems. So thank you all for joining. I'm glad to see that we have really seasoned speakers dealing with the topic, from Mr. Olamide Obajimi to Mr. Ajibola Olomola and Mrs. Oniyogi. Thank you. And to our moderator, Toby Adekoya, thank you so much for taking time out to just discuss and share your knowledge. I won't take much time, but to just remind everyone that SLP, Section on Legal Practice, will continue to be at the heart of making sure that legal practitioners continue to excel. So please mark your diaries. Our annual conference is taking place very soon, in another 40 days, from the 7th of April to the 10th at the National Theatre in Lagos. Please mark your diaries. Early bird is closing on Friday. Take advantage of that. The link to register will be in the chat box. Please register and be part of the moving train. And thank you all once again. I won't take your time, but just to wish all of us a very fruitful session as we navigate the evolving jurisdictional landscape of tax dispute resolution in Nigeria. Once again, I welcome you, and I wish you all a productive and rewarding session. Thank you. Thank you for joining.
Thank you very much, Madam Chair. Thank you for your welcome remarks. It's important that we particularly ensure we take benefit of the early bird registration for the NBA SLP conference coming up soon. Right about now, I would request that Mr. Musa Atta, SAN, the chair of the litigation committee of the NBA SLP, addresses us. Thank you very much.
Thank you, Mr. Benga. Thank you, everybody, Madam Chair. And thank you, the participants. A very wonderful good afternoon to all of you gentlemen. It's my great pleasure to welcome us to this great webinar. It's going to be our second SLP Litigation Committee webinar, which, like Madam Chair has said, we have chosen a involving topic, so that we have brought some seasoned speakers to come and do justice to the topic. And I'm sure our seasoned speakers that we have here on board, Mr. Obajimi and We have Obajemi here. We have Olamola and Mrs. Oniengi. I'm sure they're going to do justice to this wonderful topic. I would like to extend our special appreciation and welcoming them to the stage because for them to took their time and accept our invitation to speak on this topic, we deeply appreciate. And please, speakers, I would like you to sit down, relax, and enjoy just wonderful sessions. Like Madam's chair and the secretary said, we're still pleased having a very low registration turnout in our next conference. Please, let's endeavor to register. We don't have SLP is the first and famous one of the section that we have in the MBA, which combine almost all the members of the MBA, one way or the other, they are part of the section. But this time around, we don't know what happened. We'll have very low turnout in the registration of the conference. And the conference is forthcoming, and we can take advantage perhaps of the early bird so that we can enjoy a discount. And another thing is that the chair has been making all modalities and logistics, arrangements so that to ensure there is discount on almost every logistics that we are going to use to this conference. She has done so many things. I knew some of them would have been privileged to be aware of. Shows me so many. It gave me the joy to see that the Madam Chair is going on her way, out of her way to be doing such kind of it. Please, members, let's endeavor to register. I won't remember you with so many talks and this thing. I'll pass by to you. Thank you very much. Enjoy the session, sorry.
Thank you. Thank you very much, Mr. Musa Taesiem, the chair of the litigation committee of NBSLP. As Mrs. Ali and the chair had mentioned, we're looking thoroughly at the topic, the Tax Appeal Tribunal's expanded jurisdiction, resolving the conflict between the TAT and state high courts. And we have very specially in our midst, Mr. Olamide Obajimi, Mr. Jibola Olomola, and Mrs. Oniongi. Mr. Obajimi is to deliver the keynote, and later on, it will be a joy to have Mr. Obajimi joined by Mr. Olomola and Mrs. Oniongi in a panel session to be moderated by Toby Adekoya. I would quickly introduce Toby Adekoya, who is the moderator. Toby would then in turn introduce Mr. Obajimi, who would immediately take on proceed with the keynote, and thereafter he will be joined by the panelists. So Toby Adekoya is a senior associate in the corporate, commercial, and tax practice at WTS Blackwood Stone, where he advises local and multinational clients across sectors, including finance, technology, energy, manufacturing, telecoms, logistics, and oil and gas. He equally provides tax advisory, transfer pricing, and tax compliance services, and also regularly represents both resident and non-resident companies, clients in tax audits, achieving significant tax savings. So there is no one else, there's no better person that would have moderated this session with the experts we have in our midst than Toby Adekoya. So please, Toby, do the honors to introduce Mr. Obajimi, who will then immediately proceed to deliver his keynote. Thank you very much.
Thank you very much, Jay, for that introduction. Good morning or good afternoon, distinguished silks, learned seniors, and my colleagues. as earlier introduced, my name is Tobilo Adekoya, and I'll be moderating today's webinar where we'll be discussing the Tax Appeal Tribunal's expanded jurisdiction and aligning on how to resolve the conflict that has now been triggered by the TAT's expanded jurisdiction between the TAT and the State High Court. Without attempting to preempt our speaker and the panelists, I'm just a moderator, just to put that out there again. I would like to just provide a short background and identify some noteworthy points which I think that our speaker and panelists would address as we go along. As a background, Nigeria's tax dispute resolution framework has stood on the somewhat wobbly three-legged stool of the Tax Appeal Tribunal, the Federal High Court, and the State High Court. And to clarify, I used the word wobbly because until recently, and even I know that there will definitely be litigation in court as to the role and jurisdiction of the TAT and the State High Court. Only the role of the Federal High Court with respect to federal taxes seems somewhat clear and without question to an extent, right? Now, but the tax reforms of the past few years or the past 2 or so years sort of aims to restructure this framework and provide some clarity. And that reform, that whole process has been on the front burner for everyone, including legal practitioners, whatever your specialty may be, tax, oil and gas, litigation, whatever your specialty, it is an issue for you. And it's not just because you're worried about what you're paying, but because there's now a jurisdictional or constitutional conundrum that has now been established by this framework that I mentioned earlier on. Who else to give us some clarity apart from these learned seniors that we have had to, ask to come on this program today? So you don't think that I am your speaker if you've just joined after the introductions, permit me to stop here and introduce our distinguished keynote speaker, Mr. Olamide Obajimi. Mr. Olamide Obajimi is a partner in Olaniwu Ajayi LP, where he heads the firm's tax practice. He is a chartered accountant and legal practitioner with extensive experience in corporate tax structuring, general tax planning, general tax compliance, tax and other regulatory advisory, financial reporting advisory, tax planning and implementation, cross-border tax advisory and implementation, transfer pricing advisory and implementation, and tax litigation. He is known for supporting clients in various sectors in the course of tax review, tax audits, and investigations by tax authorities. He's a fellow of the Institute of Chartered Accountants of Nigeria, ICANN. He also holds an advanced diploma in international tax, ADIT, issued by the Chartered Institute of Taxation, UK. As a testament to his wealth of experience, he was appointed as the chairman of the Tax Appeal Tribunal Lagos panel or Lagos zone. Without further ado, kindly join me to virtually or electronically welcome Mr. Obajimi as he makes his keynote address. Thank you very much.
Good afternoon, everyone. Can you hear me? Sobi, can you hear me?
We can. Yes, we can.
Okay. Good afternoon. My name is Olamide Obajimi. I think I do not need any further introduction other than what Toby have said, and I would be setting the tone for our conversation this afternoon. So my keynote paper is an 18-page document, which I'm going to be going through with us. And in this paper, I try to look at the historical evolution of tax appeal in Nigeria, the pre-repeal jurisdictional framework, that is before our current regime was repealed by the new tax laws. We looked at the jurisdiction of the federal and state high courts as they had now, especially in relation to taxation. I had some judicial authority reflecting the repeal position and some of the issues, that we've had in the past. Then we look at the emerging unresolved issues and recommendation and conclusion. The Nigerian Tax Dispute Resolution Framework has undergone significant transportation in recent years, from the regime of the FIRS Act to reforms introduced by the GRB. The GRB Act represents a major structural shift by expanding jurisdiction of the TAT to cover disputes arising from both federal and state tax laws. Among other things, the reform aims to centralize statutory education, promote uniformity, and enhance technical expertise. However, this expansion raises important constitutional questions within Nigerian federal structure. Specifically, it brings into focus the relationship between the TAT, the Federal High Court, its powers based on Section 251 of the Constitution, and the residual jurisdiction of the State High Court under Section 272. The reform, while administratively attractive, generates fresh jurisdictional tension with implications for federalism, forum selection, enforcement, and appellate structure. This paper examines the nature of the proceedings before the TAT, the constitutional foundation of the federal and state court jurisdiction, the effect of the JRNA reforms, and the emerging issues that remain unresolved within Nigerian tax education architecture. Now, let's look at where we are. For those of us that did tax laws in school, some of these ordinances may be familiar. Different also trace TAT's nascent origin to the Income Tax Ordinance of 1948, under which tax appeals were heard by the Board of Commissioners, the board. The ordinance empowered the Governor General to appoint 3 members to hear appeal. And these appeal, these members, none of them must be public officers. Under the Income Tax Additional Ordinance, again in 1958, appeals were made to the body of appeal commissioner consisting of not more than 6 persons appointed by the minister. Also, none of them were supposed to be public servants. And appeal from this body went to the High Court of Lagos. Now, post-independence, the body of appeal commissioners as an adjudicatory body remained in existence till 1961, when the Income Tax Management Act and the Company Income Tax Act respectively were enacted. Under the ITMA, determination of appeal was very fact specific. For example, an appeal against assessment in relation to partnership income could only lie to the tribunal or court established by the laws of the relevant tax authority in whose jurisdiction the partnership carried on the business. So I'll move to the Company Income Tax Act. The Company Income Tax, on the other hand, provided for the establishment and constitution of a body of appeal commissioners. This body had powers to entertain appeal from any company aggrieved by an assessment issued by the tax authority. However, the right of further appeal went to the High Court of Lagos from decision of the appeal commissioners was limited to decisions exceeding £200. Companies were therefore constrained to accept and settle tax liability not exceeding £200, where such was the decision of the appeal commissioners unless they obtain requisite consent to appeal. It is noteworthy that following the promulgation of 1979 Constitution, the Federal Revenue Code, established under the Federal Revenue Code decree, was renamed the Federal High Court. Consequently, appeals from the Joint Tax Board under the ITMA lays to the Federal High Court. Post-1990. In 1993, the Personal Income Tax Act was enacted, providing for the establishment and composition and procedure for the body of appeal commissioners who were appointed by the state commissioners. The appeal commissioners were empowered to entertain appeals against any assessment considered inappropriate or excessive. Decisions of the appeal commissioners were appealable to the state high court. This appeared to apply to persons listed under Section 2(1) of the PITA. Those are members of the armed forces, members of the police, immigration, whose taxes ordinarily is due to the federal government. Well, this was seen as an anomaly, and this issue persisted till 2011 when the issue was resolved. Notably, appeals against an assessment related to partnership income could either lie to the body of appeal commissioner or to the court established under the laws of the relevant tax authority in whose territory the partnership carried on its business. Also in 1993, the value-added tax decree was promulgated, establishing a value-added tax tribunal to entertain tax appeal by taxpayers and the Federal Board of Inland Revenue in respect of any disputed VAT assessment. This framework was retained under the VAT Act, Cap V1 LFN 4. Interestingly, appeals from the VAT Tribunal led directly to the Court of Appeal, presupposing parity of status with the High Court. This perceived status was subsequently challenged before the Court of Appeal in Stabilini Bisholini versus FBR. We'll talk about this later. In 2007, the Federal Inland Revenue Service Establishment Act was enacted, Its provisions significantly alter the name, nature, and jurisdiction of the body of appeal commissioners and the VAT Tribunal, consolidating them as the Tax Appeal Tribunal. Appeal from the TAT were initiated the Federal High Court. It is worthy to note that prior to the enactment of the FRS Act, proceedings before the appeal commissioners were conducted in camera. In sum, the historical framework was characterized by a two-tier appellate system. Taxpayers dissatisfied with tax assessment will first appeal to the Board of Commissioners before proceeding to the Federal High Court or State High Court. I think at this point it's important to talk about the appeal process within the Nigerian tax architecture. First, a taxpayer that is not fine with any assessment issued by tax authority will file an objection within 30 days, and if the objection is accepted, a revised assessment is issued. And if not accepted, the tax authority will issue a notice of refusal to amend. And when that is issued to a taxpayer, then the taxpayer must appeal to the relevant appellate authority within 30 days. Let's look at some of the general challenges of generalist court in resolving tax disputes and why we think that the Tax Appeal Tribunal was a good case by the authorities. The challenges faced by generalist courts can be described as twofold. On one hand, there's the issue of determining the appropriate forum with jurisdiction to hear federal or state tax disputes. And on the other hand, there's the apparent lack of technical expertise and specialized knowledge required to efficiently adjudicate certain tax issues. The judicial debate. The judicial debate surrounding tax appeal dispute resolution framework can broadly be categorized into two distinct related aspects. This reflects both historical tension and ongoing constitutional challenges in sustainment of tax adjudicatory authority. The first aspect concerns the tension between the jurisdiction of the body of appeal commissioners and the VAT Tribunal on one hand, and the constitutionally established Federal High Court and State High Court on the other hand. The controversy was most pronounced in relation to Section 20 of the VAT Act, which empowered the VAT Tribunal to recover unpaid taxes and appears to elevate the VAT Tribunal to the status of the High Court. And this was challenged in Stabilini Vichinoni versus FRS. In that case, the Court of Appeal was invited to determine whether the VAT Tribunal had validly assumed jurisdiction in circumstances that allegedly violate the provision of Section 251 of the 1999 Constitution. The court considered the fact that revenue sought to be recovered by reference to Section 20 of the VAT Act were indeed payable to the federal government. It therefore declared that Section 20 was null and void and inconsistent with the Constitution for clothing the VAT Tribunal with absolute and sweeping jurisdiction to recover taxes due to the federal government, contrary to Section 251 of 1999 Constitution. Similar pronouncement was made by the Court of Appeal in Cadbury and FBI. The second aspect relates to the competing jurisdictional claim of the Federal High Court and the State High Court over certain categories of tax disputes, particularly where the nature of the tax, federal or state, is intertwined under the Constitution or other legislative or adjudicatory authority. A case in point is the case of Access Bank and Edo IRS, where the Court of Appeal ruled that the Federal High Court does not have the constitutional or statutory jurisdiction to hear any matter pertaining or connected to the revenue of the state. The next is the lack of technical expertise. Another challenge in generalist court approach is that the average judge in Nigerian Superior Court trained in general law often struggle with technical intricacies of Nigerian tax legislation, including economic and accounting principles that are fundamental to modern tax disputes. This deficiency in expertise frequently results in case backlog, delay, prolonged proceedings, as the court may also require extensive expert testimony and technical explanation. The establishment of the TAT as a specialized tax adjudicatory body. The historical failure of federal regular court to effectively tackle tax disputes necessitated the creation of specialized court. The establishment of TAT under the FRS Act makes a paradigm shift in Nigeria's approach to tax dispute resolution. The tribunal was conceived as a dispute regulatory mechanism specifically designed to provide expeditious, expert, and accessible resolution of tax disputes. It was created to provide a specialized forum with technical expertise in taxation, reduce the burden of conventional court, expedite tax dispute resolution, and enhance taxpayers' confidence in the fairness of the tax system. The legality and constitutional propriety of the TAT were tested in early days of its birth, when litigants began to question the power vis-a-vis the Nigerian Constitution. In NMP, Civil, and TAT, the Federal High Court considered, among other issues, whether the establishment of TAT compared with the VAT Tribunal removed or restricted the original jurisdiction of the Federal High Court. The court found that the TAT operates as an administrative framework, which serves as a condition precedent to filing an action before the Federal High Court. Further, since the FRX Act did not provide for direct appeal from the TAT to the Court of Appeal, there was no intention to supplant or sidestep the jurisdiction of the Federal High Court. What are the problems? The historical evolution leads to the development of TAT, as well as the challenges faced by courts, highlight the following problem: persistent jurisdictional conflict between TAT and the State High Court. This problem centers on whether tax disputes, particularly personal income tax and other state level tax, must first be brought before the TAT, or whether taxpayers can directly approach the State High Court. When the TAT is established to handle tax disputes, including personal income tax, the State Act holds constitutional jurisdiction instructively in Cameron versus LRS. The Lagos State High Court, relying on Section 272 of the Constitution, ruled that it had the jurisdiction to hear and determine matters relating to personal income tax as a cause of first instance. In contrast, the Lagos High Court in LBIRS versus ECOSEF held that the jurisdiction to determine dispute relating to personal income tax assessment is vested in the TAT. The court based its decision on Section 58 to 60 of the Personal Income Tax Act, concluding that the TAT and not the State High Court is the appropriate forum. I think it's important to note at this point that these two cases, the judgment were delivered in the same year, 2018. One was delivered in June, and the ECOSAF case was delivered in November. The conflicts. Forum shopping, preliminary objection, and protracted litigation. Judicial disagreement regarding jurisdiction of the Federal High Court, State High Court, and statutory mandate of TAT create opportunities for forum shopping. Taxpayer may commence proceeding in one forum, prompting preliminary objection at the TAT. A case in point is CNOC Exploration Nigeria versus FRS. This case was handled by my panel at the TAT, where the tax authority raised preliminary objection contesting CNOC's appeal at the Tribunal, despite a pending originating summons at the Federal High Court. Similarly, in TSKJ and FRS, I like the friction regarding whether the TAT is a court or an administrative panel, a distinction that followed litigation for years until it was resolved by the Supreme Court. Uncertainty over disputes involving state taxes, federal state tax interface, and non-assessment-based disputes. Similar area exists regarding state taxes, such as land use charge, business premises levy, which often fall within a state constitutional authority. However, because the AT is a federal creation, its jurisdiction occasionally overlaps with that of the State High Courts. Additionally, disputes that did not arise from formal assessments, e.g., refusal to issue TCC, issues around land use charge, who to pay, frequently leave taxpayers uncertain about whether to approach the TAT or commence an originating summons before the High Court. So we'll go into the pre-repeal jurisdiction before we have this current regime. Prior to the Joint Revenue Board Act, the TAT derived its bloodline from Section 51(1) of the 5th Schedule to the FRS Act. It was conferred with power to settle disputes arising from the operation of the FRS Act and other federal statutes listed under the 5th Schedule to the FRS Act. And these laws are the Company Income Tax Act, PPTA, Personal Profit Tax Act, Personal Income Tax Act, CGTA, Capital Gains Tax Act, Value Tax Act, and the Stamp Duties Act, Taxes and Levies Act, Regulation, Proclamation, laws of National Assembly in relation to assessment and all. Though comprising of 5 commissioners, the TAT is properly constituted if it has a quorum of 3 members at any proceedings. Then the territorial jurisdiction and zonal division. To ensure accessibility, paragraph 1(2) of the FRS Act allowed the Minister of Finance by a notice in the Gazette to specify number of zones, matters, and places in which the TAT may exercise its jurisdiction. By notice in the Federal Gazette, pursuant to this provision, the Minister of Finance promulgated the Tax Appeal Establishment Order 2009. And this order established the TAT in the 6 zones of the Federation and a special zone for Lagos and the FCT. It is worthy to note that the territorial jurisdiction of the tribunal in this zone was guided by general rules that appeal are to be filed in the zone where the taxpayer's principal place of office was located, or for individuals where the taxpayer was resident. However, this general rule was subject to certain exceptions.
Sorry, I'm trying to reduce the volume.
Such as where the company operates in multiple states or zones. The subject matter of disputes cannot be charged with activity in a particular location. In this case, the company's registered office or principal place of business. For non-resident taxpayer, it is where the activity is done.
Yes, you mentioned to
will be the relevant zone to entertain such disputes. The TAT may also transfer matters to the appropriate zone for administrative convenience. Who are parties as entitled to approve the TAT? Any person, individual or corporate that give an assessment, whether it is the tax authority, whether it's individual, whether it's state tax authority, all can approach the tax appeal tribunal. Nature of procedure for the TAT. Although the FRS Act provides that any proceeding before the tribunal shall be deemed a judicial proceeding, and that the tribunal shall be treated as a civil court for all purposes, the Supreme Court in TSKJ pronounced these proceedings as quasi-judicial in nature. Appeal before the tribunal primarily concern contested tax assessment, penalties, and interest. In addition, unresolved administrative decisions of the tax authorities, such as refusal to issue tax certificate, registration issues, and similar matters may also be subject of an appeal. Proceedings at the TAT are initiated by notice of appeal and conducted in accordance with the FRS Act and the TAT rules. As with any adjudicative forum, the evidentiary burden of proof lies on the appellant, who may rely on witness testimony, documentary evidence, amongst others. The typical procedure governing appeal before the TAT is summarized as follows. The TAT must be properly constituted with at least of the chairman, any of the members could act as chairman. The commissioner expect to recuse himself when there is a direct or indirect financial interest in the matter, or any prior professional relationship with the taxpayer. Hearing has to be held in public, and at the hearing where the FRS establishes that the appellant fails to file required returns, and that the appeal is frivolous or abusive, or that security is warranted, the tribunal may adjourn proceeding and order the appellant to deposit the lesser of the previous year's tax or 1/2 of the tax assessment plus 10% of that deposit. Failure to comply results in confirmation of the assessment and loss of other right of appeal assessment. After hearing the parties, the tribunal may confirm, reduce, increase, or annul the assessment, or make any other considered appropriate. Decision must be recorded in writing by the chairman of the tribunal, and a certified true copy shall be issued to either party upon request within 30 days, subject to appeal provision. Where then the appellant fails to produce proper account, produce incomplete or unsatisfactory record, neglect to comply with the tribunal notices, or refuse to answer relevant question without reasonable cause, the chairman must record these particulars in written decision. We move to the jurisdiction of the Federal and State High Court. The jurisdiction of the Federal High Court is derived from Section 251 of the Constitution. This provision bears the Federal High Court with exclusive jurisdiction over specified civil matters and causes, including matters relating to the revenue of the federal government, taxation of companies, custom and excise duties, import duties, fee for mining license, and taxes from petroleum and mineral. In addition, paragraph 17 of the 5th schedule to the FRS Act grants the Federal High Court appellate jurisdiction over the TAT. Notably, the Federal High Court's jurisdiction over matters relating to the revenue of the government of the Federation has caused friction and what has been described as an overlap with the tribunal's jurisdiction. With respect to state high courts, state high court, including the High Court or the FCT, established under Section 270 and 257, respectively, of the Constitution, have unlimited jurisdiction over civil and criminal matters. Specifically, Sections 257 and 272 provides that the State High Court shall have jurisdiction to hear and determine civil proceedings in which the existence or extent of illegal power, liability, privilege, interest, obligation, or claim is an issue, or to hear and determine any criminal proceeding involving or relating to any penalty, forfeiture, punishment, or other liability in respect of an offense committed by the person. The jurisdiction of each State High Court is made subject to the Federal High Court and therefore does not extend to matters specified under Section 251 of the Constitution. Consequently, any civil and criminal proceeding in relation to other tax matters within a state, including the enforcement of state and local government tax, fall within the competence of the State High Court. state tax laws and revenue matters. Beyond the federal tax statute, state government possess the constitutional authority to make laws imposing taxes, levies, and fees within their territory, insofar as such taxes fall within the concurrent or a residual matter. Examples include the State Internal Revenue Service establishment laws, the personal income tax laws of various states, the property tax laws, land use charge laws, entertainment and gaming tax laws, hotel and restaurants consumption tax laws. Also, the taxes and levy approved of collection, although later deemed unconstitutional by the Federal High Court in AG, Rivers, and FRS, identified specified taxes and levies collectible from federal, state, and local government. Under the Taxes and Levies Act, state government were authorized to administer personal income tax, withholding tax, capital gains tax on individuals, stamp duties on instruments executed by individuals, pool betting, gaming taxes, amongst others. However, the intersection of federal statutes, such as the PITA, with state administration, creating vexing jurisdictional issues. Specifically, it was unclear whether states needed to establish their own tribunal or revenue court, or whether the TAT or the state high court should retain authority over state administered personal income tax disputes. Judicial authorities, which have reflected this pre-repeal or the regime before the current regime. Conflict between the TAT and the Federal High Court. The primary conflict stems from Section 251 of the 1999 Constitution, which grants the Federal High Court exclusive jurisdiction over federal revenue. This contrasts with the FRS Act, which not only empowers the TAT, but under paragraph 20 of the 5th schedule deem it a civil court. Critically, paragraph 17 of the same schedule limits appeal to the Federal High Court to point of law only. This creates a vexing jurisdictional issue, as it deprives the Federal High Court of its constitutional responsibility of determining issue of law and facts in revenue matters. This apparent conflict in the jurisdiction of the Federal High Court and that of the TAT has been subject of several litigation and judicial pronouncements at the TAT, the Federal High Court, and the Court of Appeal. Prior to the enactment of the Joint Revenue Board Act, early judicial responses were inconsistent. We have the restrictive view, as was seen in TSKJ and FRS. The Federal High Court in Abuja declared the TAT's jurisdiction void, only that it encroaches on the Federal High Court exclusive constitutional mandate. Same was also the case in NNPC and TAT. We have the judicial, quasi-judicial view, which was seen in FRS and General Telecom, where TAT had argued that its deemed status as a civil court proved it an administrative body, not a constitutional court, and thus did not violate the provisions of Section 251 of the Constitution. This divergent view and persistent conflicts have largely been resolved by the Court of Appeal and the Supreme Court. For instance, in CNOC and NNPC and others, overturned the decision of the Federal High Court and upheld the tribunal's ruling to the effect that the tribunal's jurisdiction does not infringe on the exclusive jurisdiction of the Federal High Court, since an appeal to the tribunal is a condition precedent for filing an action at the Federal High Court. The Supreme Court in TSKJ, which I had mentioned earlier, reinforced the position that the TAT is not a court of law, but an administrative tribunal carrying out quasi-judicial function and empowered to adjudicate tax disputes. The Apex Court equally held that the TAT's existence and powers are not incongruous or incompatible with the judicial authority of the Federal High Court, but exist to complement the dispute resolution framework under the FRS Act. Further, it was held that the deemed status of the tribunal as a civil court did not elevate the TAT to the status of a constitutional court. For it were a court, then it will not need a provision deeming it as one. We'll move to the encroachment of the State High Court original jurisdiction. A secondary conflict exists regarding the State High Court under Section 272 of the Constitution. State High Court have original jurisdiction over matters outside the exclusive jurisdiction of the Federal High Court, including state administered taxes like the personal income tax. However, the FRS Act notably omits any reference to the State High Court. Specifically, paragraph 17 of the 5th schedule to the FRS Act directs that all appeals from the tribunal must go to the Federal High Court on point of law. As such, the FRS Act failed to account for the constitutional jurisdiction of the State High Court over disputes involving capital gains tax and personal income tax for individuals. in Lagos State Internal Revenue Service and ECOSAF. The Lagos State High Court held that Section 58 to 60 of the PITA, Personal Income Tax Act, the jurisdiction over PIT assessment in the TAT, effectively divesting the State High Court of its jurisdiction. Similar position was taken by the Court of Appeal in Rector Ile-Ife and Osun Internal Revenue Service. Conversely, in Skybank PLC versus Kwara State IRS, the Court of Appeal held that neither the FRS Act nor the PITA could confer jurisdiction on the TAT over taxes due to state government. In the recent decision in Plateau State Internal Revenue Service and Just Electricity Distribution PLC, it modified this position. In this case, the Court of Appeal held that the TAT has jurisdiction over personal income tax, capital gains tax, and stamp duties as they are federal legislation, notwithstanding that they are administered by state in relation to individual. The State High Court retained exclusive jurisdiction over state-created taxes, that is, revenue accruing to a state pursuant to the law enacted by the State Assembly. We'll go to the part 6 of the paper. We talked about the repeal of the FRS Act by the Joint Revenue Board Act. On 1st January 2026, a new set of tax laws came into effect, namely the Nigerian Tax Act, Administration Act, Revenue Service Act, and Joint Revenue Board Act. Importantly, the Joint Revenue Board Act established, among others, the Tax Appeal Tribunal, the Joint Revenue Board, which replaced the Joint Tax Board, and introduces a new administrative body, the Office of the Tax Ombudsman. This new regime expanded the jurisdiction of the Tax Appeal Tribunal. Section 23 of the Joint Revenue Board Act establishes the TAT and confers upon it the jurisdiction and power to settle any tax dispute and controversy arising from the administration of the Joint Revenue Board Act. While the Joint Revenue Board Act substantially retained the provision of the FRS Act relating to the TAT, it significantly expands the tribunal's jurisdiction. Some salient changes include that the TAT may now entertain disputes arising from laws enacted by the House of Assembly of the state. The TAT may now entertain liquidated money claims and appeal initiated by way of summons. The Provisions of Evidence Act now applies to proceedings before the Tax Appeal Tribunal. With the decision of the tribunal law encompassing tax disputes under both federal and state tax laws, effectively streamlining and unifying the tax appeal processing, it appears that the constitutional conflict over the appropriate forum for state administered taxes has been dealt with. However, this unification may pose constitutional challenges to the state in view of Section 272 and 257 of the Constitution. The legislative intention to strengthen tax appeal tribunal and specialized tax code. The enactment of Joint Revenue Board Establishment Act reflects a deliberate legislative effort to reposition the Tax Appeal Tribunal as a central and specialized forum for tax dispute resolution in Nigeria. This intention is most clearly manifested in Section 29 of the Joint Revenue Board Act, which significantly expanded the scope of the TAT beyond federal taxes to encompass disputes arising from the Nigerian Tax Act, the Nigerian Tax Administration Act, and any other tax enacted by the National Assembly or State House of Assembly. This expansion is not incidental. It's a structural reform aimed at addressing the long-standing weakness in the Nigerian tax administration and adjudication framework, including jurisdictional fragmentation, inconsistent decision, and inefficiency associated with generalist court. It is expected that this expanded jurisdiction will lead to centralization of tax dispute resolution, promotion of unity and consistency in tax dispute adjudication, maximizing technical expertise and efficiency, reduction in multiplicity of tax-related litigation. What are the emerging and unresolved issues? The constitutionality of tax appeals tribunals expanded jurisdiction. The expansion of the jurisdiction of the TAT under the Joint Revenue Board Act to encompass disputes arising from state tax laws enacted by the State Assembly raises fundamental constitutional concern. While the objective of creating a centralized and specialized tax dispute resolution forum is now the case of Plateau State Internal Revenue Service and Joint Electricity Distribution Company demonstrate that such expansion insofar as applied to state-created taxes is inconsistent with the constitutional allocation of legislative powers in Nigeria. Thus, there is bound to be jurisdictional tension between the TAT as established under the Joint Revenue Board Act and the State High Court. Section 270 of the Constitution confers on the State High Court residual jurisdiction over matters not expressly excluded by the Constitution. and reflect the federal structure by reserving the application of state law matters to state courts. It's a settled constitutional principle that no statute may override or diminish the jurisdiction conferred by the Constitution. Accordingly, any provision of the Joint Revenue Board Act that purport to derogate the constitutional jurisdiction of the State High Court may be vulnerable to constitutional challenges and liable to be declared null and void to the extent of its inconsistency. Can you please mute yourself? Someone is speaking. Further, Nigeria operates a federal system in which state taxation powers exercised pursuant to its residual authority form part of its fiscal autonomy. Thus, policy consideration such as uniformity and efficiency, however desirable, cannot override the constitutional allocation of legislative and judicial authority. From shopping, the overlapping jurisdiction encourages strategic litigation where taxpayers and revenue authorities choose between the TAT and the State High Court based on perceived favorability, recreating the very uncertainty the reform sought to cure. There is also a real risk of conflicting interpretation of the same state tax statute, parallel proceeding, and erosion of legal certainty. Let's go to the Enforcement and Appeal Complication under the Joint Revenue Tax Act. Under the JRBNA, TAT decisions are to be registered at the Federal High Court for enforcement purposes. However, practical difficulties may arise where the underlying liability relates to the taxes imposed under state laws. In such circumstances, enforcing a state tax obligation at the judgment of the Federal High Court within the state may present procedural and jurisdictional challenges. Additionally, the Joint Revenue Board Act excludes the State High Court from the appellate process and confines appeal from the tribunal to the Federal High Court, even when disputes arose from state laws. This intensifies the constitutional concerns outlined above. The expansion of the TAT's jurisdiction may also have systemic implications for access to justice and procedural efficiency. With only 8 zonal offices nationwide, the absorption of tax disputes risk congested cost lists and delays unless institutional capacity is significantly enhanced. Difficulty arising from the application of the Evidence Act to the TAT proceedings. As I highlighted before earlier, the Joint Revenue Tax Board now requires the application of the Evidence Act in TAT proceedings. Historically, the TAT operated as a flexible, with the flexibility typically of a quasi-judicial body, where substance prevailed largely over form, and the speedy dispensation of tax disputes was critical. However, the new requirement mandating the application of the Evidence Act to the proceeding before the tribunal may mean that the tribunal loses its informal edge, transforming principally from a form of fact to a form of law. Additionally, the strict technicalities and procedural requirements of the Evidence Act require specific set skills that effectively sideline non-lawyers, such as accountants and tax consultants, who traditionally represent taxpayers at the tribunal. Under this regime, proceedings and documentation must strictly abide by the rigid elementary provisions of or risk dismissal. A consequential effect of this may prolong hearing, which among others undermines the tribunal's intended efficiency. That there is a legislative defense in retaining the security deposit. We earlier discussed the fact that the security deposits was said to be unconstitutional. So let's go into this. The Joint Revenue Board Act retained the requirement for a security deposit in certain circumstances, which require that tribunal may direct taxpayers to deposit either 50% of the full amount of disputed tax charge, where the tax authority has proved one or more criteria to sanction of the tribunal, while the Joint Revenue Board Act deletes the additional 10% payment previously required by under the FRS Act. The core pay-to-play mechanism may remain, although this provision is framed differently from the subsidiary legislation, such as the TAT Procedure Rule 2021, and introduced condition precedent to the payment of deposits. Its retention may be interpreted as a legislative defiance to judicial precedent that have struck down similar requirements. In the landmark case of Joseph Bodurin Daudu, SAN, and Minister for Budget and Planning and so on, the Federal High Court deemed such mandatory deposit provision under the TAT procedural rule and the Federal High Court FRS practice direction as unconstitutional, null and void, and contrary to the principles of fair hearing. The Federal High Court ruled that such mandatory deposit constitutes an unconstitutional embargo on the right to appeal. Also in Investment Holding Limited and FRS, Emenite versus FRS, the tribunal held, among others, that the security deposits were discretionary rather than mandatory under the previous FRS Act framework. By reinserting this requirement into the Joint Revenue Board Act, the legislature has essentially bypassed previous judicial nullification of this provision in subsidiary rules. Whilst the doors may not have settled regarding the payment of security deposit, considering that the Court of Appeal and the Supreme Court is yet to make a pronouncement on the issue, the effect is clear. Its retention risks transforming a legal right to appeal into a financial luxury that may intermittently force taxpayers to settle on fairness of judgment assessment, simply to avoid financial paralysis. Let me go to my conclusions. In view of the resulting overlap between the TAT and the State High Court, the following recommendation may be considered. Constitutional amendment. If centralized tax adjudication is intended as a permanent structural feature, then constitutional amendment expressly defining the TAT jurisdiction will eliminate uncertainty. Also, Section 251, 257, and 270 of the Constitution may be amended to include TAT as a considered condition precedent for tax matters. Legislative amendment. As an alternative to the above, due to the rigorous requirement of amending Constitution, the Joint Revenue Board Act may be amended to clarify whether the TAT's jurisdiction over tax disputes is exclusive, concurrent, or subject to state adoption. In addition, the Joint Revenue Board Act should be amended to modify the evidentiary and security deposit provision in the manner that preserves procedural efficiency and ensures expeditious and substantial justice, the bivocation of the appellant pathway. The appellant rules should be restructured to focus on the nature of the tax rather than the nature of the tribunal. Thus, appeal involving federal taxes may proceed to the Federal High Court and those regarding state taxes to the State High Court. Decentralization of tax appeal tribunal. Rather than a single federal TAT attempting to overreach into state procedural matter, states should be encouraged to establish their own specialized tribunal. An alternative is to create more TAT zone or ensure that there is a tribunal in every state capital. This will ensure timely adjudication of disputes, particularly given the expanded jurisdiction over state law, tax laws. Ultimately, the Joint Revenue Board Act represents a bold leap towards uniformity and harmonization. However, unless judicial boundaries are clarified judicially or refined legislatively, the very reform designed to achieve coherence in tax adjudication may continue to generate constitutional uncertainty. Thanks for listening to me. Thank you.
Thank you very much, Mr. Olamide. Please, can we put our hands together virtually to appreciate Mr. Olamide for that really insightful and fantastic presentation. I want to believe that participants would likely maybe get a copy of your presentation, but I would yield that to the coordinators and organizers to make that decision. But I see that there are a number of people requesting to have a copy of the presentation because it's a really fantastic presentation. Thank you very much for your recommendations. My thinking or my hope is that the Presidential Reform Committee will probably reach out to you to, think about amending the laws. But I personally don't see an amendment happening in the immediate term. Anyways, so as to keep within time, I would like to introduce our panelists or discussants, as you may want to refer to them. First, and our panelists will be joining Mr. Obajimi, to address some questions that have come up in the course of this presentation. First, I'll be introducing Mrs. Bolanle Ajara Oniyogi. Mrs. Bolanle Oniyogi is the Director of Litigation and Prosecution at the Nigeria Revenue Service, NRS, a seasoned legal practitioner with over 30 years of experience. She holds an LLM from the Nigerian Institute of Advanced Legal Studies and has obtained higher education from various notable institutions, both within and outside Nigeria, including Harvard. As a tax administration and litigation expert, she's driven milestones in revenue service, earning numerous awards for excellence. She's a former coordinating secretary of the Tax Appeal Tribunal and a member of professional bodies such as Nigerian Bar Association and the Chartered Institute of Taxation Nigeria. She also plays a key role in key committees such as the Presidential Fiscal Policy and Tax Reform Committee. So for someone who, was in the process of making these legislations, or this, for in this case, the Joint Revenue Board of Nigeria Act, it's very important that we have someone like this on the panel. So can we please welcome Mrs. Oniyogi to be part of the panel. Secondly, Mr. Ajibola Olomola, sorry. Mr. Olomola is a partner in the Tax and Regulatory Services practice at KPMG Africa. He serves as the head of the Deal Advisory M&A tax practice in Nigeria. With over 36 years of professional experience, he has constantly delivered strategic value to clients across a broad spectrum of industries and sectors of the economy, including telecommunications, media and technology, government and financial services, consumer and industrial markets, pharmaceuticals, oil and gas, power and utilities, manufacturing, etc., within Nigeria, Africa, and globally. Mr. Ajibola is a lawyer and has advised government agencies, tax authorities, industry sector associations, several local and multinational institutions, conglomerates, financial service companies, private equity and investment firms, leading engineering and construction firms, consumer and industrial market entities, among others, on various business investment, portfolio management, and tax and regulatory services. He has also garnered deep experience in advising clients on various investment regulations, trade agreements, and customs. He has delivered regulatory compliance to support both local and multinational clients. I think that Mr. Ajibola is also a very important person who we should have on this kind of panel to look at the conflict that has sort of come up as a result of the expanded jurisdictions of the TAT vis-a-vis the jurisdiction of the state high court. As we go along on this panel, our hope or the aim is to explore some of these challenges, which thankfully Mr. Obajimi has addressed, that has arisen as a result of the Joint Revenue Board of Nigeria's Establishment Act, while also providing practical guidance and forward-looking insights, into how to address these challenges. So, without further ado, Mrs. Oniyogi and Mr. Olomola, can you please confirm that you are with us so we can get into it?
Hello.
Hello, ma. Good afternoon, ma.
Right here, moderator. Good afternoon.
Ajibola
here.
Okay, thank you very much, sir and ma. All right, let me start with, I think maybe I should pass my first question to Mr. Ajibola. In light of these changes, what are some of the most, at this stage, I'll just do some of the simple questions before we go into some of the technical ones that address the issue of the conflict. So at this stage, Mr. Ajibola, what are some of the significant practical implications for businesses that are operating in various states? And how does this expanded jurisdiction, affect taxpayers? And generally, how does it affect taxpayers and their disputes? I don't know if that question makes sense.
Indeed, it does. Thank you very much, Mr. Moderator. A very good afternoon to everyone present and to my fellow panelists, Mrs. Oniyogi. I would like to take the opportunity of the podium to make a few remarks about the very worthy presentation made by Mr. Obajimi, who himself is a chairman of the Tax Appeal Tribunal Lagos, and so brings a wealth of practical experience to the subject matter. It's a very well-researched and presented paper, and I think it will be a seminal paper that most participants will find very useful as an addition to their law libraries. There are 4 comments I'd like to make on that paper in the interest of time before I then respond to the question you've asked me, if I may. Mr. Moderator, or would you like me to just ignore that and go straight to the question?
Go ahead, sir. Please go ahead. I think that's very good. And then Mrs. Oniyogi can also make her comments, if
Absolutely.
any, after you respond.
Absolutely. Yes. It's a very, very well delivered paper, and I find myself in agreement with this trust, the foundation that he had built, and also the conclusions he had arrived at. But there were a couple of matters I thought I should stress for the benefit of everyone. The evolution of income tax on individuals in Nigeria is itself what has lent what has created the problem statement that we're addressing today. Because initially at independence, income tax was not a federal matter. Income tax for individuals was left for the regions. So if you looked at the ITMA, which Mr. Bajimi had referred to, you will find that the provisions of ITMA affected states only. So federal had no input into that. In fact, personal income tax only became a federal matter in 1979. So that was the overreach that took the power away from the states, centralized the power, but left the power of collection in the hands of the states, which then created a dichotomy. The power to legislate was reserved for the Federation in the exclusive legislative list, whilst the concurrent legislative list allowed the states to collect the taxes. So it then raised the question, is this tax a federal tax or is it a state tax? Now, most states viewed that as a usurpation of their powers, but they continue to treat income tax for individuals as a state matter, particularly because they were the ones collecting it in any event. And the real test would be, will the states be accountable to the Federation for the income tax collected from individuals? And the answer was no. States were not accountable to the Federation for that revenue. In fact, states treated the revenue as part of their internally generated revenue. So it didn't go into the Federation account, it went into the account of the states. And appeals or challenges to the administration of that tax was a matter that was sent to the body of appeal commissioners in each state and not to a federal body. The federal body only came into existence much later on when the TAT was created. So if you watch the evolution of income tax on individuals, you will find that the question at the crux of the matter is the question whether that income tax, whether it should be viewed as a federal tax, which is what it is today under the Constitution. The 1999 Constitution lists income tax or taxation of persons. Taxation of income of persons is listed in the exclusive legislative list, which means that only the National Assembly can legislate on income tax. So income tax on individuals is not a state tax. Therefore, in resolution of the question, where should appeals on disputes around income tax go? Income tax on individuals will not be a state tax matter. It will be a federal matter. That will be the way to answer that question. And that is the way the courts have answered that question in cases like the Plateau State case and the Access Bank case, Access Bank and Edo State. So it is only National Assembly that can pass law on that. But you will find that some states, for example, Kaduna State, have made laws around the administration and collection of these taxes. Now, the effectiveness of those laws in view of the exclusive legislation list can be interrogated further. If you then come to the concurrent list and the power of states to make laws on the concurrent list, you will say that collection of taxes is a matter that is concurrent and states can make laws. That's correct. However, in the Attorney General of Ogun State case against the federal, and in the Attorney General of Lagos against Eko State, against Eko Hotel, the doctrine of covering the field has been well established. And so for any matter that is on the concurrent list, where the federal government has legislated on such a matter, that legislation covers the field. And states no longer have jurisdiction to pass laws on that matter. So it will seem to me that with the passage of the NTA, and prior to the NTA, the passage of the Personal Income Tax Act, which sets out administration compliance, and the passage of the FRS Establishment Act, all of which have now been subsumed into the Nigeria Tax Act, the NRS Act, and the JRB Act. I think that everything related to income tax, even of individuals, including administration, collection, and the like, are legitimately within the purview of the National Assembly and the federal government of Nigeria, whilst the states have to comply with the administration of those laws. Those are my views, and I think I find support in some of the cases cited by my learned friend and chairman, Mr. Obajimi. The second issue I would like to stress for the listeners is the evolution, the clear path in which the revenue-related dispute resolution has traveled in Nigeria. So we started with having dispute resolution first reserved for the state high court. And then in 1973, the Federal Revenue Court was established, which was then changed in 1979 to the Federal High Court. And so the Board of Appeal Commissioners used to be initially, when they were initially set up, they used to be the place to go to prior to appeals from that BAC to the State High Court. Then at some point, the direction of appeals was rerouted from the State High Court to two courts, either the Federal High Court or the State High Court, depending on the context. And I think that's also part of where this gap has been created, because at some point in 2007, under the FRS Establishment Act, that was streamlined into appeals following one corridor only, TAT to Federal High Court. And that is what has then led to the interesting question: what happens to appeals from the TAT on matters on which the state has jurisdiction? Again, remember, it's not just income tax. There are other taxes that the state has power to legislate on. For example, if you looked at the Taxes and Levies Act, which itself has been struck down by the Supreme Court, but is now being revived in one way or another, you will find that you could have entertainment tax, you could have consumption tax, hotels, and other occupancy taxes that states have power to legislate on. The question is, should appeals or should controversies arising from those taxes, should those be sent also to the TAT? And if they are sent to the TAT, should appeals from that also go to the Federal High Court? Why should the Federal High Court be exercising jurisdiction over revenue of the states? And I think you will find that in two of the cases that have been cited by Mr. Obajimi, the courts have been very clear that appeals on state revenue matters should not lie to the Federal High Court. But there's no provision in the law, there's no route in the law for such appeals to go to the State High Court. Having said this, there is a potential slip in the Joint Revenue Board Act. If you look at the second schedule, so even though Section 29 has been addressed by Mr. Obajimi, which talks about appeals to the Federal High Court, if you look at the second schedule, paragraph 10.1 and 10.3, you will find that in paragraph 10.3, there's reference to appeals to the High Court without saying whether that is Federal High Court or State High Court. I think it's a slip. I think it's clear that it's Federal High Court that they mean, but that in itself could provide a way of escape if future legislative action can be taken to expand the definition of appeals and allow appeals to go in a potential two direction as opposed to a unilateral direction. So rather than have appeals exclusively to the Federal High Court and then to the Court of Appeal, you may have appeals bifurcated by reference to the nature of the appeal. If the appeal is in relation to a matter which affects the revenue of a state, other than a matter that has been covered, where the doctrine of covering the field would apply, that's arising from collection of taxes. Anything other than that affects the revenue of a state, appeals should go to State High Court. But where the matter is about federal revenue or matters on which the federal government has legislated, such appeals should go legitimately to the Federal High Court. And the last matter I would raise before I come to the question asked of me is in terms of the direction of things. I think Nigeria would have to answer the question, what future do we envisage? What does tomorrow look like in terms of tax or revenue-related dispute resolution? We now see the trend in which the TAT is going. It is becoming more and more formal. Prior to 2007, the body of appeal commissioners used to work in a very informal manner. You'd go there, it was very fact-based. It was not evidentiary. Rules of evidence were not strictly applied. More focus was on determining what the correct tax was and making sure that things were resolved in a very quick way. But when you go to TAT today, it's almost like going to a court. Firstly, it's full of lawyers. Secondly, the rules of the TAT are modeled on that of the Federal High Court. Again, looking more and more like a formal court. Now, the GRB Act is saying that rules of evidence should be applied also at the TAT. So there's a clear movement towards formalizing the TAT, and I think eventually we should get to the point where TAT should be set up as a proper court, if that's the direction we want to go. But in doing so, Mr. Obajimi has highlighted some of the reasons why a more informal dispute resolution mechanism may be suitable. And we see that that is the path that has been followed in other countries, like in the UK, for example. So we may then say to ourselves, do we want a fact-based resolution mechanism, or do we want a very formal resolution mechanism, in which case we elevate TAT to a Federal High Court, make it a very litigious environment, and take our chances with the effect on our revenue? Or do we leave it as a fact-based informal approach, which is what it is today? And in making this statement, I'm guided by the fact that Nigeria has instituted a tax ombudsman program for the very first time in our tax lexicon. We now have an ombudsman in place. So is it the case that we will strengthen that ombudsman process and make it more of the informal dispute resolution, and then have the TAT as a formal court? Is that the direction we want to go? I raise this as teasers for us all to consider, and I know that the NRS is also here. Ms. Onyongi will have a chance to speak in a minute or two. So what is the overall vision that we have for dispute resolution in Nigeria in revenue matters? Should it be TAT as a court, or should we step back from the precipice and bring TAT back into an informal, fact-based dispute resolution mechanism? Those will be the comments I'd like to add to the very good paper that has been delivered by my learned friend, Mr. Obajimi, chairman of the TAT, Lagos. In terms of the question put to me as to practical implications for businesses in various states, I will answer that very simply because I've taken a lot of your time. I think you will find that on matters that arise relating to disputation around revenue of the states, most businesses will have to think very long and hard as to whether they should not take those matters directly to the state high court. Because if you were to take it to the Federal High Court, there's no pathway for eventual resolution. Because even if you get a judgment at the TAT, that judgment cannot be enforced. If you want to appeal, you cannot appeal to the Federal High Court because the Federal High Court has no jurisdiction over state revenue matters. So going to the TAT would appear to be a waste of time. So in recent times, in many client situations that I've been involved with, despite the fact that we believe that TAT is the right place for these matters to be adjudicated, it's composed of judges that are experienced in tax matters, economic matters, law, and the like. So they will give you the best hearing you can possibly have. But the question then is, how do you enforce that judgment? Because states won't recognize it. And Federal High Court cannot enforce its judgment there. And there are rulings that say Federal High Court has no jurisdiction. So it may appear that in those instances, clients will have no choice than to consider very seriously going to the state high court so that their disputes will have a better chance of being enforced if resolution is achieved. But I can tell you that this is not where most clients want to be. So the appeal we will make is that the lawmakers should please consider whether or not modifications can be made to the Joint Revenue Board Act to allow certain appeals to go to state high courts. But it's a matter that will have to be resolved tomorrow and not today. Today, that problem statement will exist. I thank you very much for for the time afforded me.
Thank you very much, Mr. Ajiwa. I think that your contributions have really enriched, what we're here to do, because you even addressed some of the points I was going to raise. For example, I was going to ask whether it's really time for the TAT to be upgraded to a standalone court, but you have addressed that and you've raised some of the points. But I think I would still direct that question to Mrs. Oniyogi for her to give us sort of maybe the perspective from the NRS's, point of view. And for someone who was in the room when these laws were made, I see that she was a member of the presidential committee. So I think it would be very nice to have, your thoughts, ma, on whether or not it's time for the constitution to be amended. I know that the process to amend the constitution, may be lengthy and all that, but maybe it's time to set up the TAT as a standalone court like what we have with the NIC, and then modalities can be worked around as we go along. But maybe in 3-4 minutes, if you can just share your thoughts on that. Thank you.
Okay, thank you, Mr. Chairman, for the well-researched paper you just presented, and my co-panelists. Thank you for your contribution. Like a lot of conversation have gone around this issue of TAT. Is it ripe for it to be a court? We have to go down memory lane again. What is the reason for establishment of TAT? The chairman, this speaker has already gone down memory lane, right from ITMA, why we have this dispute resolution mechanism. In an evolving tax administration that demands rapid changes, we have undergone a lot of reforms. And this tax appeal processes is part of the reform processes. And it gives us a premium position in tax administration that we have something like a TAT in place. Because if you look at the composition of the TAT, we have most often is only the chairman that is a lawyer. There are some panels that have just one lawyer, and the others are tax practitioners, maybe accountants, public administrators, who over the years they have been involved in tax practice. And the other benefit is that taxpayers, when they go to TAT, they are there in a relaxed atmosphere that is devoid of all the seriousness that we have in the court of law. So they are more relaxed. In fact, there are many instances where taxpayers have chosen to conduct their cases by themselves. They are consultants, accountants. They have conducted cases on behalf of their clients, and some other taxpayers who have conducted their cases on. I've witnessed this in many instances. So, and this is a cost saving too for the taxpayers, because we know that when we go to court, this is not certain how long this matter is going to take. We know that in the tribunal, the time frame for disposal of cases within 3 months, 6 months, and they are done. And these panelists, they are well averse of the accounting principles, the tax principles, unlike what we have in the court of law, where many of us, we have never read taxation. Even though we are learned, we know that we have to accept that tax is a technical subject, and there are many, many technical issues involved. So it's very important for us to know that we have to go put a round peg, a round hole, for us to achieve the desired results that we aim for. So for me, I think TAT is good. Is a good mechanism for resolving disputes. And not far from that, we have to look at the scenario. You know, whenever laws are amended or made, there is a lacuna, or there is something we want to cure. That's most likely. That's why we have laws made. So this section 29, the reason for it to be in this law is because we have had series of cases on whether TAT has jurisdiction over state laws. We all know that most taxation in Nigeria, most tax laws, they have all federal enactments. Be it PITA, stamp duty, VAT, they are, and CITA, even though CITA is exclusive for company, they are all federal enactments. And even though the PITA is mostly administered by the states, but it's a federal enactment. And it also, the CAT has jurisdiction pursuant to the defunct Section 59 of the FRS Act, which makes PITA one of the laws that TAT has jurisdiction to advocate on. And we have had series of cases on whether TAT can entertain cases arising from revenue of state laws. Being subject of several judicial decisions in Nigeria, it cuts across all the states of the Federation. In Abuja Investment Company Limited versus Federal Capital Territory, it was whether the tribunal has jurisdiction to entertain appeal from the Federal Capital Territory Tax Administration Law. And the court held that TAT has jurisdiction to entertain tax matters under both federal and state revenue law. And this was even before the JRB enactments. Also in Olumide and Oyediran, Lagos State Internal Revenue Service. Can you hear me?
Yes,
So
yes,
we
yes,
have
ma'am.
okay. So we have this. Okay. So I just want to be sure that I'm speaking to the audience. So whether the TAT has jurisdiction over matters arising from application of state laws. And most times, the TAT always hold that they have jurisdiction to entertain matters from the PITA. But when the state laws are made laws as regards to development levy, entertainment of consumption tax, or what have you, so the TAT will say they will restrict themselves to the issue of the federal law, which is very clear in the law that is PITA. So we have quite a range of cases, like I've said, from across the states of the Federation. We have Shell Petroleum Fathers, River State Board on Veterinary Revenue. It's still on the same issue of whether TAT has jurisdiction over state laws. Coca-Cola Nigeria Limited versus Delta States and the FIRS. It's still the same issue of whether TAT has jurisdiction as it was then constituted to decide on matters that was made by the states houses of assembly. But for me, I feel that Section 29 has to be read in conjunction with Section 10 of the or paragraph 10 of the second schedule of the JRB. If you look at the heading, it says appeal to the Federal High Court. I can say, like was rightly said, I was part of the committee. This is not, it's not supposed to be Federal High Court. It's supposed to be appeal to High Courts, Federal and State High Courts. But the State High Court was omitted. So, but if you now look at sub 3, you can see that the intention of the draft map here, where the relevant tax authority is dissatisfied, relevant tax emphasis, relevant tax authority, which is to show that it's not restricted to the federal tax authority alone. This satisfied with the decision of the tribunal, it may appeal against such decision to the High Court on point of law by giving notice in writing as specified in subparagraph 1 to the secretary within 30 days after the date of such decision was given. On receipt of a notice of appeal under subparagraph 1 or 3, the secretary of the tribunal shall cause the notice to be given to the chief register of the High Courts. High Court with all the exhibits tendered at the hearing before the tribunal. Then the chief judge of the High Court may make rules providing for the procedure in respect of appeals made under this act. And until such rules are made, the High Court rules relating to hearing of appeal shall apply to the hearing of an appeal under this act. this for me shows clearly that this provision is meant to cater for the appeal that borders on states' internal revenue laws to go to the state high courts. This is very clear with this sub 3, 4, and 5, because it is very clear here that high courts is not restricted to only federal high courts. It's the intention of the draft men, and when we did the committee, I believe, I'm not speaking for the committee, but I know that what we intended, taking into consideration the judgments of courts on the Sky Bank and Para State's internal revenues and some other judgments that I've mentioned here, and those mentioned by my chairman and Mr. Olomola. So it's very clear for me that this law intends that the state revenue services, when they are dissatisfied with the decision of a TAT, they go to their states to appeal against the decision, and because the Federal High Court already has an appeal rules in place. So this provision is to cater for the state high court, which provides that the chief judge of a state may make rules for appeal. And if they don't have, they can make rule with what they have. So for me, I think that what the law intends is to make state high courts to appeal their decision of TAT to the state high court, state revenue services, to appeal decision of TAT to the state high court, and not to the federal high court. So it was just the heading that was a misspell. So it's supposed to cater for both the federal and the state high courts. So that is the primary point we have to take note, and we all know that laws are always subject to review. So this is something we can take note of, and then we make note of it, and then the appropriate amendment is made to make it clearer. But if you look at the heading and the content of the provision, is very clear that this is supposed to cater for state high courts too, for state high court to entertain appeal from decision of TAT. So I'm sure that in time we will be able to have some other provisions that will cure all these impediments, so that it will give room for clarity, because I know that TAT is a veritable tool for resolving disputes arising from taxation. If we want to leave it to the state high court, though some of them, they don't have the necessary wherewithal to entertain disputes arising from tax laws. And then we will now be back to square one. The impediments that we want to cure, then we will not be able to cure it. So I believe that what's supposed to be done is to make the necessary amendments to the law, to the JRB Act, so that it will be made explicitly clear that appeals from issues that borders on state revenue laws that's culminated into appeal to TAT, after the decision of TAT, can always be appealed to the state high court. If it's a state law, and if it's a federal law, it can go to federal high courts. And what normally happens either so is once a TAT judgment has been delivered, as a NRS, Federal Inland Revenue, now NRS, what we used to do is to go to the federal high courts and register such judgments under Foreign Reciprocal Acts, so that we register it as if it's a judgment of the federal high courts. And after the registration, then we applied to the courts under the sheriff and civil procedure rules for the enforcement of that TAT judgments. So that's the way we enforce the judgment of TAT. And I can assure you, we have enforced quite a number of judgments delivered by TAT in favor of the FRS, now NRS, by taking these steps. So
Thank you very much,
on the issue of So you want me to stop now? Okay.
Unfortunately, because of time, in the interest of time, so we don't, because I'll still need you, Mr. Ajibola and Mr. Obajimi to make, I think, just one more final comment because of time. But I think there's still this controversy, because when we look at that rule that you had made reference to earlier on, in the first schedule, that section 10 that you had made reference to, the first
Section 10, yes, section 10.
yes, or of the first schedule, it says any person dissatisfied has to go to the Federal High Court. But then when we come to 3, that slip that Mr. Ajibola made reference to, still exists. But I think that I think that the issue at this stage will now be for amendments down the line. But until that amendment is made, I think that this conflict, this challenge, this controversy would still remain in force. I just like to say, as we go into these the final round of this panel, if you have questions, please just drop them in the chat box so that we can have your thoughts. So I think my other question now would go to Mr. Obajimi. Thank you once again for that really brilliant presentation. And please, I'd like you to keep your response to maybe just 2 minutes or 3 minutes max because of our time. We wouldn't like to, keep people longer than we had promised. Earlier on, Mr. Ajibola had made reference to the fact that the doctrine of covering the field, applied in the Eco Hotels case. I wanted to ask, do you think that that doctrine can be said to apply in this case, in the sense that Section 29, seems to diminish the residual jurisdiction of the State High Court, but can an argument be made that the principle of covering the field applies, and so therefore there is no really need for us to worry about, the challenge or controversies that we think arises? Mr. Obajimi.
So on the issue
of 2 minutes, please.
So I'll keep it very, very short. On the issue of covering the field, I do not think that will apply, because where there are constitutional provisions, right, with respect to powers that has been given by the Constitution, then issues around covering the field, shouldn't apply. You could talk about covering the field in relation to statutes made by the federal, and the states, and seeing whether there are issues around exclusive or concurrent lists. The way it talks about powers that are, given by the Constitution, then we shouldn't have any conversation around covering the field.
Thank you very much. Thank you very much, sir. I think I'll now pass my next question to Mr. Ajibola. So because of time, 2 minutes, please. Do you foresee, or apart from these amendments that we're looking at, do you think that there's any opportunity for state laws to now align with the TAT's expanded jurisdiction, or there is no really solution, or unless we say, okay, is it that this law is deemed unconstitutional, or this provision is deemed unconstitutional, or nothing, or we find a way for state laws to align themselves with these provisions of the JRBN, or on the alternative, can subsidiary legislations be made sort of to address these conflicts? Mr. Ajibola, your thoughts?
Thank you very much. And I think Mrs. Oninyongi has already given insight, which I agree with, in terms of the direction that should be followed. There will be elements that can be interpretative, and we can look for ways of saving the provisions. There will be elements that will need to be amended when there are opportunities to further review the law. But the most important thing I will contribute to the question is what the JRB has been able to do successfully. When the Joint Tax Board was initially created, there was not a lot of powers given to it. It was more like a talk shop. Under the new JRB Act that has been passed by the National Assembly, with, of course, the salutary work that we've seen the Fiscal Policy Reform Committee do JRB has been created as a resolution mechanism in itself. And that resolution mechanism, if you look at the JRB Act carefully, one of the powers given to the JRB is fiscal policy determination. And so they have an ability to coalesce among themselves, the 36 states, come up with ideas, recommend that to the minister, the National Assembly, the president, and then have laws made, amended, whatever. So I think you will find that the JRB will be a very potent force in the future of this country in determining the path to which fiscal federalism will be exercised and the path to which, for example, even dispute resolution will be exercised. So you will find it instructive that provisions for the tax ombudsman were included in the JRB Act and not in the Tax Administration Act. That in itself is suggestive of the direction of travel. Thank you very much.
Thank you very much for that response. Again, if you have any questions, can you please just share them on the link? And also, I see that the admin has mentioned that the materials will be sent to participants' inboxes. Before I go on and take questions from the chat, but I think I'll just ask one final question so we can look at what other jurisdictions are doing. So, Mrs. Oniongi, are there any precedents from other federal systems? Nigeria claims to practice a federal system of government, right? Are there other precedents that, we can adopt or that we see that has resolved this kind of jurisdictional conflicts? Mrs. Oniongi, in just about 3 minutes. Thank you.
Yes, you know that there are no two systems that are the same.
Yes,
you understand? There are no two systems that are the same. But what I know that in India, they have this appeal process in place. And it's one of the countries that are Nigerian model when they establish this appeal process. And even in England, they have the first tier tribunal and the second tier tribunal. So you know that tax shapes business. Because if the dispute will always arise from taxation. So if the taxman and the taxpayers, they are not able to resolve their dispute, they will not be able to move on with their business successfully. So the only reason that we have this conversation is because we have some slips in our laws, and it is not unexpected. There is no perfect law all over the world. So we make mistake to correct ourselves to be in a better and formidable position. And I'm hopeful that this introduction by JRB to the provision of the TAT to accommodate all states of the Federation is a very welcome development. And there is room for us to correct whatever slip we have here. And if you look at the recent judgment of TSKJ on versus FRS, this issue of jurisdiction of whether TAT can entertain dispute of tax, taking into consideration provision of Section 251. The apex courts said TAT is created to settle disputes as a panelist who comprises of
this is the one where you all man see that time now. I don't know much about it.
So I'm very hopeful that we will leverage on other jurisdiction, on the judicial precedents, and the amendments that we think is very desirous to make in the circumstances of this case, so that we'll be able to move forward and make this tax dispute resolution a very favorable tool for the taxpayers and the tax authority to settle disputes that comes up in the course of their engagement. Thank you.
Thank you very much, Ma. Thank you very much. I think what I really take away is that we need to start from where we are, right? And then
Yes.
down the line, we can really amend the laws. Because really and truly,
Yes.
as I say to people, there is no perfect law. As you have also rightly
There's
said,
no
there's
perfect law
really no
anywhere you
perfect
go.
law. Is the thing with man-made laws, right? There's really no perfect law. There's no way we can have a situation where the laws will be without reproach. So it's fine that we have this controversy. And on a lighter note, that's an opportunity for us as lawyers to make some money. So if there's no controversy, then there's no opportunity to make money, right? So I think my final question would be to Mr. Obajimi. Clearly, constitutionality overrides considerations such as efficiency and uniformity, especially as we claim to practice federalism. What do you think can be done at this stage now that we are commencing implementation, right, to align these for the benefit of the government and the taxpayer? So we want to align uniformity, efficiency, clarity, these general policy considerations. How do you think we can align these in the where we are now without going down the line of amendments and all that, for the benefit of everyone involved? Thank you.
So, if you ask me, I think one of the things that is currently going on is the JTB, as they were now Joint Revenue Board. They've been trying to see how they can harmonize the states, sign memorandum of understanding between the states, have bilateral, arrangement, especially in relation to some of these local tax laws. We've heard, the president of the fiscal committee talking about the fact that all the nuisance taxes needs to go. But the authorities making these nuisance taxes have the powers to make these taxes under the laws. So what they are doing is, I think, is the right step in the right direction to try and, sensitize, have their periodic meeting to discuss how these tax laws will be effectively and efficiently managed, such that, the controversies that we've highlighted, in this meeting, will not be a clog in the wheel of tax administration and tax adjudication. We understand the fact that one of the indicators of doing business globally is an efficient tax appeal system. So if we now have a tax appeal system that's a clog in the wheel of justice or tax administration or tax adjudication, then this will constitute a problem. So JTB or JRB, as they are now, they are advising states, they are collaborating, they are trying, to harmonize laws. And I understand that they are also meeting to see how relevant provisions in the Constitution can be amended, so that the framework we have will have less hurdle for arguments and for dissatisfaction. Thank you.
Thank you very much. I think if I know any member of the JRB, I would like to say kudos to them, because that's some good work. So I'll just take one question from the chat box. I can see one question. I think somebody else raised the question as to getting the compendium of tax appeal decisions. I think maybe the person can look at the tax law reports. That may be helpful. Before I take final comments from everyone, from all the panelists, I'll just like to take the question that I see on the group. Someone is asking, would an alternative approach in the future be to create a specialized tax division of the Federal High Court of Nigeria, in contradistinction to making the TAT a constitutional tribunal on equal standing with the FHC and the state high courts?
Can I?
Yes, I was going to pass that to you and Mr. Ajibola. So maybe when you give your thoughts, Mr. Ajibola can give his thoughts in just 2 minutes each. Thank you.
Okay, if you can recollect when Mr. Ajibola was during his presentation, the Federal High Court was established as a revenue court. It was established as a revenue court. But with time, because of oil, Nigerians, we are not bothered with taxation. So the court was not having cases much as it borders on taxation. So that's why the Federal High Court now became open to all cases. So it is for us to develop our jurisprudence. When we have issues that, just like we're having this conversation, any other class issues, we ventilate it. So with that, it will metaphors and it will grow. Then this, just like some people are talking about being in the constitution, it is the antecedents, it is the move, it is the agitation that will metaphors for it to be recognized as a court and be in the constitution. So the ball is in our court. Let us improve the tax jurisprudence. Let us ventilate the issues, just like we are having this conversation on all other issues that bordered on taxation, so that as the issues come up more often than not, then the system will be ripe for it to be listed as a court in the constitution. Thank you.
Very much, ma. Mr. Ajibola, your thoughts in just 2 minutes.
Thank you very much. Mrs. Oniyongi covered the field very admirably. I agree with everything she said. I will only add to what she has said, that if you look at the character of cases that are dealt with at the TAT, a lot of them are matters that lend themselves to simple resolution. And the people who sit on those matters are very experienced practitioners. You have people who have served at the NRS for donkey years. These are people who have not only been administrators, they've been they understand it. You have economists, you have tax practitioners, you have accountants, you have lawyers who are sitting as judges at the TAT. So they're able to cut through the complexities very quickly. And you will find that it is only on matters of law that you are allowed to appeal to the Federal High Court, because then the lawyers can do what they do best. I think there will always be a place for non-litigious resolution of tax disputes. And that's why I would like to make another call that we should step back from the precipice of converting the TAT into a very formal litigious system, which seems to be the direction of travel currently, where you are now having, like I said in one of my comments in another forum, the Evidence Act has enough people worshiping it every day in court. It doesn't need another forum. Let TAT, imagine if we are now having to be serving subpoenas on each other at the TAT. Oh yeah, Federal, NRS, that document I filed with you. Oh yeah, go and, because NRS will be the person in custody of my tax computation, for example. So if I'm appealing to the TAT, I'll first have to subpoena NRS to come and bring the original copy of the tax computation I submitted to them. When I can just bring forward my copy and everybody can look at it and we can see where the error is. So I think we need to step back from that. We don't need all that. We also need to look at the rules of the TAT again. They don't need to be modeled on the Federal High Court. Front loading, witness statement, we don't need all that. A lot of matters don't even need witnesses. Submit your tax computation, we'll see immediately where your error is. So I think that's where we should be going. Making things simpler, not making it more complicated. Thank you very much. And if you compare the number of cases that have been dealt with at the TAT, that is pressure off our already congested courts. Imagine if all those cases had to go to the Federal High Court. They will have nothing else to do. So I think we need to step back, make the TAT more efficient, and let the Federal High Court be there to intervene when you need a court to make orders. Thank you very much.
So, and if I may just add to Mr. Olomola's assertions, right? I think we should step away from formalizing too much formality for the TAT. And, when you decide to upgrade the TAT to a regular court, some of us who, like me, will not be there, because I'm not sure I want to leave practice completely, to sit on the bench. And if you look at the quality of people that sit at the TAT, for example, my panel, I have a retired director of FRS, experience, over 30 years experience. I have a former president of the CITN, immediately past president, who sits at my panel. I have an associate professor of tax law from University of Ilorin. He's a member of my panel. I have a very experienced tax lawyer, very senior lawyer, who sits on my panel. And myself, with my little experience as a lawyer and chartered accountant over the years, you hardly will see those kind of quality in one person sitting in a regular court. So I think I align myself with the position of Mr. Oniyongi and my Oga Ajibola Lomola, and we should step away from formalizing the TAT into a regular court. Thank you.
Thank you very much, Saz. I think that I really don't even need to ask you to make your final comments, because I think and I see that you all have the same thoughts. There are challenges, there are problems with the laws as they are, but we can improve the laws, we can amend the laws, but we even really need to look at a way to make them less complex, less formal, right? So that we can, the way we have speed with dispute resolution in tax, we can maintain that momentum, so we don't have to go down the road of, evidence, as you said, subpoenas and all that, that can make things significantly complex. Because of time, I don't know if anyone has any last thing to say, after which I'll yield to Mr. Gbenga Ajala to give the vote of thanks and closing remarks. Just anything to say in 1 minute max. Mr.
Okay,
Bajimi.
if you permit me to start, and then the chairman,
yes.
Mrs. Onyonga, and then the chairman can then wrap up.
Yeah,
I would like to congratulate the section on litigation and legal practice for organizing this seminar. It's on a very topical issue. It's also on a set of laws that have revolutionized the face of revenue collection in Nigeria. The set of laws comprising the Nigeria Tax Act, the Nigeria Tax Administration Act, the Joint Revenue Board Act. These laws are seminal. They change everything, and they require everybody to get involved. It's brand new. Nobody knows it all. So I encourage all members of the Bar Association, those who are here and those who are not, to get involved in this. It's a law. Nobody understands laws better than lawyers. You can guide us all into how to interpret the laws, how to apply the laws, identifying gaps, and so on and so forth. So I congratulate this section for deeming it worthy to raise this seminar on a very important issue that has agitated the minds of several judges, as represented in the cases that Mr. Bajimi has highlighted, and many are still in court as we speak. I congratulate you all. Thank you very much.
Thank you, sir.
Okay. I saw that somebody was asking where they can get the judgments of the tribunal. So you can get some of the judgments in the law reports. And we have a tax law report of Nigerian revenue law reports. And you can equally go to the websites of the tribunal. You can get some of the past judgments there. So they are all available, and I know that some stand at the state high court, court of appeals, who do have some of the past judgments of the tribunal. I join my colleagues in congratulating the litigation committee for hosting this webinar, and congratulate all our colleagues too for the benefits to gain from the insights of the paper presented and the contribution by the panelists. Thank you very much.
Having my learned seniors, lead, I'm not sure there's anything I want to hide again. I just want to say, lawyers, we're over 400 here. When we have tax issues, let's ventilate them at the Tax Appeal Tribunal. We have very seasoned practitioners that will look into those matters with diligence, with the spectrum of a prism, and see it from all angles. Thank you very much. Have a nice afternoon.
Thank you very much. At this point, I'd like to yield to Mr. Gbenga Ajala to make the vote of thanks and closing remarks. But I also like to say thank you very much for this opportunity. I do not take it for granted. Thank you.
So yes, so beyond the regular conversations that we find on social media and in certain circles around how to tag certain transactions and, the very pedestal type of conversations, I think this webinar has driven home a very few points that I'm sure would rest with most people that have participated. Today, the vote of thanks is my honor to invite my alternate chair of the litigation committee, Mrs. Chinasa Umegbunam SAN. It's important that we bring the big fish to appreciate the big fish that have taken out their time to speak to us and be members of today's panel. Mrs. Chinasa Umegbunam SAN, please. Thank you.
Thank you, Wenga. And thank you on behalf of the chair of the SLP, the SLP Litigation Committee chair and members. We want to say thank you to the panelists, the lead speaker and the panel. It's been such an insightful session. You know, sometimes you get on these webinars and you're wondering, you know, what you're going to get from it. I'm certain everybody that was on this webinar today had, you know, learned something new, even for some of us that have been in practice for a long time. So a massive thank you from the litigation committee. Thank you from SLP, our moderator, Mr. Olomola, Ms. Soini Mr. Baba Jimmy, and Tobilola Adekoya. Thank you for honoring our invitation, taking out time from your busy schedule to come to talk to us about this topical issue that starts everywhere you go. It starts. Everybody is talking about that because, you know, they said there are two certainties in life, death and taxes. So we that we are alive for now, we're interested in the taxes and the ones that are going to come out from us and the ones working for clients as well. So thank you, and we hope that when we call on you again, you'll be available to give us your time. And thank you, Wenga, for putting this all together. And lastly, another word again on the SLP conference. Please register to attend. It's going to be insightful. Many panels talking about topical issues. So if you haven't registered, please try and register to attend. Thank you and well done, everyone. Back to you, Wenga.
Okay, so thank you. This officially brings to a close the webinar. We tried to ensure that 2 p.m. to 4 p.m. stood intact. Thank you for making out time. Like the admin has said, all CPD points will be communicated via email. Also find time to, you know, join and register for the NBSLP conference. And as you would imagine, these kind of conversations are very important and timely. It's not all webinars that are boring or, you know, we actually discuss very topical and, you know, very topical issues. So thank you, everyone, once again, and have a great week. Thank you.
Thank you. Bye.
Thank you, too.
Thank you. Thank you.